So on the 12th of October 2017, Richard Boyle, who worked for the ATO, lodged a public interest disclosure, so formally blew the whistle about what he observed to be unethical directive given by a senior leader in the debt business line of the ATO. It related to the issuing of garnishee notices and effectively an inappropriateness associated with those. Are you aware that a PID was lodged?
Yes, Senator, we are.
Thank you. Now, on the 27th of October, so 15 days later, that PID was rejected by the ATO. Mr. Ball then lodged a redacted version of his PID, of his public interest disclosure, to the IGT, the Inspector General of Taxation, as a complaint. Were you aware of that? Are you aware of that?
I might have to take that on notice. We're generally aware of the fact that the PID was made, but as to the exact detail, I might need to take that on notice, Senator.
And then as a result of no action in that space, it's clearly public knowledge that the ABC ran a Four Corners program called Mongrel Bunch of Bastards, which aired on television, and basically alleged the ATO wasn't playing by the rules. And Mr. Boyle appeared on that program, so I'm sure you're aware of that.
I'm aware of it, but obviously matters that relate to television programs are something which may or may not be relevant to the decision making at the Commonwealth DPP.
Then he was in the 4th of January 2019. He was charged for copying and disclosing taxpayer information to the media, and I don't want to go to anything around that, but that's just as a statement of fact. He's now before the court on a number of charges. Okay. Following that, in May of that year, the Inspector General of Taxation released a review into the ATO's issuing of garnishee notices, stating inter alia, problems did arise in certain localised pockets with the issuing of enduring garnishee notices for a limited period, particularly so at the Adelaide local site. So that was the finding of the IGT. So in essence, the IGT found that there were problems in the very area that Mr. Boyle had raised in his public interest disclosure. Now I just want to take you to the second document that I've provided, which is the outcome of a Senate committee, and I'll take you to paragraph 5 of that in the last sentence and just summarise. It says, the committee is concerned that the standard of the ATO's investigation could appear to the public to be superficial in addressing the serious concerns raised by ATO whistleblowers. So, in effect, if we go back to the second step in my other letter...
Senator Patrick, I'm sorry, I'm just trying to find that reference in the document.
Paragraph 5.
The second, it's the two last lines.
Yes.
Oh, yes, right. Thank you.
Thank you, Attorney.
Thank you.
So the bottom line is, just in summary, this is a guy that blew the whistle. He saw something going wrong. He's blown the whistle formally. We now know, the Senate has looked into this. We now know that that was a superficial investigation, and you'll see the comment I've put is, but for the superficial nature of the ATO investigation, all the remaining steps would not have happened. And so my question goes to the public interest considerations in deciding to prosecute. Did the CDPP look at the scope of everything that happened? Because the problem that this causes, or the perception that any reasonable person would have, is Mr. Boyle, he made a public interest disclosure, it was rejected. We now know the ATO failed in its processing of his public interest disclosure. He then tried again with the IGT. failed again, and then went to the media. And we know that there has been laws that have changed as a result of these actions, and indeed the IGT has made findings that support his PID. Most people will look at it and say, this is a case where someone tried really hard to follow the rules, blow the whistle, and ends up being prosecuted.
And Senator Patrick, just to suggest that you need to be very careful to distinguish between these issues and the substantive claims or the case which is obviously underway at the moment.
So
can I just confirm?
I'm not going to guilt
is
or
this
otherwise.
Before a judge alone, or is this before a judge and jury?
It's listed for a 21-day jury trial commencing on the 6th of September 2021.
Look, all the facts I've
And
laid out are...
In what court, Mr.
That'll be in the South Australian, I think it's the Supreme Court of South Australia.
The South Australian. So on the basis...
District Court, I beg your pardon.
On the basis of the fact that this is a Supreme Court trial... District Court. Before judge and jury, I particularly just ask you, Senator Patrick, to be very cautious about making any comment that might inadvertently... influence any factual matter before the court.
Chair, in terms of the subjudice provisions, I think that, as my understanding, is that these proceedings can't be used in a court of law. And Senator Patrick is entitled to ask the questions which are to deal with.
And I'm not going specifically to the charges, Chair. The charges are very different to what I'm talking about.
I understand that, and you've made it very clear the basis on which you're raising that question. That's correct, Senator Carr. They can't be used as admissible evidence in the court. But what can happen is that reporting of these proceedings may influence a jury in particular, particularly when it's not just a proceeding relating to matters of law, when it's a proceeding relating to matters of fact, particularly before a jury, there is a higher risk. So I'm just asking Senator Patrick to be very cautious in that respect.
Let's go very generically. I've put out the facts on the table. When the DPP considers the public interest, you could see the chilling effect that has on anyone standing by. They look and say, someone's tried to do the right thing in a couple of different ways, hasn't worked for them. We now know there was a flaw in a particular process. Charges are then laid, and it looks to the lay person, the reasonable person, that someone who tried very hard to do the right thing, and in fact raised an issue that, in the end appeared to be present, it has a really big chilling effect. There would be no one in Australia aware that looked at those facts and didn't think that I'm not going to whistleblow. It actually has effect on every Australian, and it's in that context I ask whether, in the decision to prosecute, the CDPP had regard to that aspect of the decision making.
Thank you, Senator. Well, our focus has been with respect to the evidence in the matter, and so the decision to prosecute in this case was based upon an assessment of the evidence and an assessment of the evidence applying the prosecution policy of the Commonwealth. So applying the policy, it was determined that there was a prima facie case, a reasonable prospect of conviction, and that the prosecution was in the public interest.
So I might just direct this at the attorney now, because I'm not suggesting when I look at the rules that you operate to, if you look in the very narrow sense of perhaps allegations that were made and evidence that you've collected, that there's a case to at least put to a judge and jury. But attorney, you can see in the broader perspective, and this is where your particular role comes into play, and I do refer you to section 71(1) of the Judiciary Act, which gives you a right to decline to proceed in a prosecution, and I know that's a big step, and I'll just point out what the federal court said in relation to that.
And Senator Patrick, when you refer to you, we just have to be cognisant that you're referring to the position of the Attorney-General, given
Correct.
that
It's the position of the Attorney-General.
the Attorney has been in this current role for 6 weeks. So I just want to clarify that.
Noting she did a law degree in the UK, I prefer the Lord Chancellor, but we'll stick with the Attorney-General. Anyway,
Everything went wrong that you studied in the UK.
Okay. Attorney, in the federal court in Re Evans ex parte Klein, 1984 case, I'll just read a couple of snippets. The Attorney-General's first law officer has always borne the ultimate responsibility...
Sorry, I don't want to interrupt you, Senator Patrick, but when you're referring to a particular case and reading out from the judgment, Attorney, do you need to refer to that judgment, or are you...
I'm happy for Senator Patrick to put
the question.
The paragraphs to you.
Sure.
Thank you.
So I'll just start that again. The Attorney-General, as first law officer, has always borne the ultimate responsibility for prosecution decisions and the legislation enacted, in this case they're referring to England, to establish the DPP. But that doesn't alter your position in relation to the fact that the attorney may discharge his, and in your case her, ultimate responsibility to the Parliament and to the people for the conduct of prosecution. So you have an overriding role, and I accept the bar is very, very high, but you could perhaps see in the circumstances of this particular case that the DPP has looked at this quite narrowly, but perhaps noting the really significant chilling effect that this may have on the government's whistleblower policies. I wonder, and maybe it's something you might want to take on notice, maybe it's something we have to take offline, whether it really is in the public interest to continue with this particular prosecution.
Senator, I will take that as a comment from you, because as you have noted and as the CDPP has articulated, the prosecution was brought because the Commonwealth Director of Public Prosecutions made an independent decision that the prosecution of this particular person is in accordance with the prosecution policy of the Commonwealth. You are also correct, though, in relation to Section 71(1) of the Judiciary Act or Section 8 of the Director of Public Prosecutions Act. You would also be aware of the fact that the exercise of these powers is reserved for very unusual and exceptional circumstances. And I'm actually advised that Section 71(1) of the Judiciary Act, which predates the CDPP, has not been used since the CDPP was established. But I will consider further the issues you have raised, but they are the points I will make.
Sure. It just really is, you could see how someone could look at what's happened here and simply say, no one should ever blow the whistle again. Because if someone makes a mistake in the PID process, doesn't do the investigation properly, they'll end up going to jail. And that's not what we want. And I know in the negotiations between you and Senator Xenophon how important you regard whistleblowing as a feature that should exist within our organisations to avoid corruption and misconduct and a whole range of other things.
I'll take those as comments. Thank you, Senator Patrick.
All right. So I understand you said you'll at least consider what I've put to you today.
I will have a look at what you have referred to, but I've made it very clear the prosecution was brought because the Commonwealth Director of Public Prosecutions made an independent decision.
Sure. Okay. Thank you very much, Chair.
Thank you very much, Senator Patrick. Senator Scarr, you've just got a couple of questions.
Follow-up questions just in relation to the same issue. Acting Director, I have a legal background as well, so I certainly respect your independence and congratulate you and your team on the wonderful service you provide to the people of Australia.
Thank you, Senator.
I also want to speak in terms of some generalities in relation to the prosecutional decision, deciding whether or not to prosecute or not to prosecute. As I understand it, reading your policy, one of the things you have to, one of the factors you consider in making that decision is whether or not a prosecution could be counterproductive in all the circumstances. So in that situation, is it relevant as a general rule to consider whether or not, for example, that prosecuting someone who claims to be a whistleblower could have a consequence of, to use Senator Patrick's terminology, of having a chilling effect on other public servants in a position where they see something as unethical behaviour and want to come forward and bring that to the public's attention to shine a bright light on it so that action is taken to try and address the situation. Is that the sort of thing you would typically weigh in terms of considering whether or not you should proceed with a prosecution?
Yes, thank you, Senator. Certainly the prosecution policy has a deliberately broad framework established for consideration of questions of public interest. There's a range of matters that are set out in the policy, but it's a non-exhaustive list. And when prosecutors make that assessment, they'd be entitled to weigh up the sort of factors that you've referred to in your question as to whether it would be in the totality of the material and in the circumstances of the offending in the public interest to proceed.
And something else that you might consider, as I understand it, you consider the impact on the victim in terms of a potential crime. Now, in this case, it's an interesting. I don't want to be particular about this case, but in a circumstance, I'll tread the line. In a circumstance where, a whistleblower circumstance where there's private and confidential information relating to individuals, and you have a government bureaucracy that's seeking to keep its information confidential, but the person is actually accessing the information with a view, with an intent, with a motivation of actually helping the individual citizens, is that something that would typically be weighed up in the process? How do you weigh up the interests of, say, the individual citizen whose information is being stored and needs to be protected, as opposed to the interests of the bureaucracy or the government agency? Is that something you need to weigh in terms of making that decision?
I'm not sure I'd put it in, and again, I don't want to speak about the particular case because those very matters might be matters that are litigated in that prosecution. So I think it's best that we take it out of that context. But certainly impacts on victims are very important to us in any decision or whether to prosecute or not. And at one extreme in our practice, we see cases where we've got victims of a very horrific child sex offending, for example, where the victim's interests in the matter are pretty significant. As opposed to right up the other end of the spectrum where some people might have used the term sort of victimless crime, but it's a broader crime that might have been committed on the revenue, for example. So they are matters, and no two cases are the same, but our prosecutors are acutely aware of the subtle differences or stark differences in some instances, and we apply the policy, a prosecution policy, consistently in those circumstances.
Right, okay. And in terms of considering all the relating surrounding circumstances, and I note that you said it's a broad, you look at a broad ambit of circumstances and background. Would one of the things you might consider, if you'd had the benefit of considering it at the time, that government reform or change in policy actually was made as a result of or at least in part due to attention that might have arisen from the actions of someone who might have engaged in particular conduct. So if you look at the totality of circumstances from the act to the ultimate outcome, there's actually been a change in government policy in a particular regard. Have you ever come across, let me put it this way, have you ever come across circumstances like that? Because I would have thought they would have been extraordinarily rare and limited to a very, in a great nature. Have you ever come across a circumstance like that?
I can't say in my experience I have, Senator, but the policy does talk about the obsolescence or obscurity of the law that's being that's the subject of the decision whether or not to prosecute. And we sometimes have laws where it's on the statute books at the time, but then there becomes a subsequent change in the law which might impact on our decision when we look at the offending that took place at the time. So that occurs, but I can't say I've had experience where there's a particular disclosure that's made which impacts in the way that is put by the Senator's question. So,
would it be fair to say that then has elements of being an extraordinary case, an extraordinary case, which wouldn't typically come before the CDPP? In terms of assessing those situations, a case where there's been some conduct, but ultimately, at the end of that conduct, there's actually been policy reform, a change, announced change to law to change a process to take into account what was uncovered through that act. Is it fair to say that is a set of extraordinary circumstances?
It would be an unusual case, Senator.
Would be a very unusual and rare and extraordinary case, would that be correct?
Well, in my experience, it would be quite rare because I can't.
So this, of course, leads to the next question as to how experienced you are, and I know that elevating to the position you're now in, you must be extraordinarily experienced, Mr. Brockhard. Could you perhaps outline the degree of your experience in terms of prosecutional activities?
Yes, Senator. I've been a prosecutor for about 33 years. 33
years?
Yeah. So I've got a fair few runs on the board in that sense.
You have more runs on the board than Bradman, and I thank you for everything you do, and wish you and your team all the best. Thank you.
Yes, Senator Patrick.
So just in relation to that decision to go forward and prosecute, I presume in any circumstance there's some report that or some documentation that's associated with that, with any particular prosecution that you make?
Yes, that's correct,
Okay.
Senator.
Is that something you ever share with the attorney in terms of, just understanding that the attorney has an oversight role by way of statute in respect to prosecution? Ultimately, she is responsible to the Parliament for oversight, for the carriage of that particular government activity.
Well, we prepare those documents. We apply the policy very carefully, but we also guard our independence as a very important.
But you accept no independent authority acts without oversight on. We frame our constitution to avoid that.
I understand that,
Yeah.
but obviously we're set up for the
Sure.
purpose of acting independently in
you to be
relation to the
independent too.
decision whether or not to prosecute.
Yeah.
So we generally don't, provide material to the attorney in relation to our decisions to prosecute. That's not something that we generally do.
Okay, and this will be specific to the case, and you may choose not to answer this, but in the case of Richard Boyle, was one of the things that was documented that
Sorry, Senator Patrick.
Can I at least ask the question?
Well, as long as in the question you're not disclosing any facts which might influence a jury.
Okay, in the context of in the context of Richard Boyle's, the decision to prosecute Richard Boyle, in the documentation associated with that, was the effect of that prosecution on whistleblowing more broadly considered? Would I find something, if I were able to look into that document, would I find something on that topic?
Well, we constantly review the cases that we have before the court. On occasions, defendants or their legal representatives write to us and provide us with fresh material and ask us to review the case. And on other occasions, we'll conduct that review on our own motion if we become aware of relevant information which would impact on our decision to continue the prosecution. So in this case, it has been reviewed and it was recent.
But from that perspective of the chilling effect on other whistleblowers?
Well, it was certainly reviewed conscious of the fact that there'd been material around the PID which had been ventilated in the Senate report.
So, but that's not the same thing as what I talked about. That's about a defect in the PID processing. I'm just talking about in general.
I'm sorry, Senator, it goes to the question as to whether we're aware of the PID effectively and the process. As to the broader question of whether our decision would have a chilling effect, I'd probably have to take that on notice as to whether that was discussed in detail in any of the submissions that were prepared by our lawyers.
All right, and if it wasn't, maybe I can just suggest it should be, and I'll leave it at that.